So welcome to our constitutional law class tonight. So we have concluded discussion of constitutionalism, separation of powers. And tonight we want to discuss the rule of law, the concept of rule of law. What does it mean? How did it evolve? How does it manifest? Are there shortcomings or limitations regarding how the concept is understood, how it is practiced? So those are the matters we are going to be exploring in this lecture. And we would like to say at the outset that rule of law is the cornerstone or the foundation of constitutional democracies, as well as the very fundamental principle, the basic thing in every civilized legal system, which seeks to ensure justice, fairness, equality within a society. If these values are important, then rule of law is a must, it's not an optional. So rule of law is basically to the effect that all individuals, institutions, and entities, both public and private, including the very state itself, the state machinery, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated. So that is the basic essence of rule of law. And as we often say, no one is above the law. All of us are subject to the law. So that is a very mundane or very ordinary way of trying to articulate rule of law, so to speak. Despite centrality of the concept of rule of law, it is a concept which is multifaceted, has various dimensions, various angles. And at the same time, it is contested. Contested in the sense that we've not always had consensus around what rule of law is. And particularly so when we were discussing constitutionalism, you will have appreciated that just as having a constitution will not automatically translate into constitutionalism, will not automatically translate into the conviction that there should be restraint or limitation on powers of government or those who wield governmental authority. But there's the need for a certain ethos, certain culture within the particular body politic, particular polity, particular society, that we hold these values and cherish them. In the same vein, it's not enough to say that we should do things in a way which conform to the law, and that is rule of law. That will be a very simplistic, naive approach to rule of law. Of course, the contestation or the various disagreements regarding the concept of law, the varying interpretations across a different legal system, are referable to different cultures, different historical experiences. So all those shape how rule of law is understood in various contexts. So you first of all try to unpack the meaning of rule of law. At the very core of the concept, rule of law is the principle that law should govern a nation as opposed to being governed by arbitrary decisions of individual government officials. So it is the antithesis, is the opposite of arbitrariness, capriciousness, as it were. And for that matter, rule of law stands for the idea that all members of society, including those in government, are equally subject to publicly disclosed legal codes and processes, legal norms and processes, which are publicly known. And I'm sure you have heard that ignorance of the law is no excuse, because of the assumption that before the law is made, every member of society, through legitimate means and processes, will have been made aware of the law, as in the case of Ghana, through publication in the Gazette. Because when a publication is made in the Gazette, the assumption is that it's communicated to everyone. So some of the core elements of the concept of rule of law is supremacy of law. Supremacy of law, that is, law is the supreme authority in society, and no individual, including head of state or governmental officials, is above the law. And this idea of supremacy of the law ensures that power is exercised within a framework of well-established and transparent laws. And no wonder, if you take our Constitution, the preamble statement, among other things, we have certain values, certain convictions, which are very dear to us as a society. So if you read the preamble, after saying so many things, we, the people of Ghana, and the exercise of our natural, and so on and so forth, will come and say that, and in solemn declaration, affirmation of our commitment to freedom, justice, probity, accountability. Then the principle and universal adult suffrage, the rule of law. So the rule of law is actually enshrined in our Constitution. And having said that, the rule of law is enshrined in our Constitution, the next question which will arise is that, yes, if you take the Constitution, if you go to Article 295 of the Constitution of Ghana, it is headed interpretation. So it's the interpretation provision of the Constitution. And what it does is that it is like the dictionary of the Constitution, meaning that where you encounter certain words and you want to be sure whether they be given a certain meaning, a certain definition by the frameworks of the Constitution, you go to the Constitution, that Article 295, to look it up if it is there. So let's go to Article 295. If you look at Article 295, they are arranged in sort of like alphabetical order. Now, you will not find rule of law written there. And yet, the preamble of the Constitution is saying that Ghana has expressed its commitment to what? To rule of law. To rule of law. Now, so how should we understand rule of law? Is there any standardized meaning? Now, if we look at the literature, if we look at constitutional law discourse over the centuries, certain key elements can be teased out as reflecting in the concept of rule of law. And one is supremacy of the law. 2, equality before the law. Every individual is subject to the same laws, with no individual or group enjoying special legal privileges. And the point of this element is to promote fairness and prevent discrimination based on status, wealth, or power, or as we see in Article 17 of the Constitution of Ghana. We'll come and discuss that in the course of the lecture. The various criteria on basis of which no one should be discriminated against. So equality before the law. Then accountability. Government officials and institutions are accountable under the law. The actions must conform to legal requirements. And for that matter, they can be held responsible for abuses of what? Of power. And that is why, if you take even like the president, where the president has even breached his office or his official oath, presidential oath, it can be a ground for what? For removal from office. Another core element is fairness in application. Laws must be applied uniformly and firmly to all individuals. So you don't vary how you apply the law, depending upon who is affected by it. So there's supposed to be impartial enforcement and adjudication and unbiased courts. No wonder if you take judges, our judicial oath will, for example, say that I will uphold sovereignty and integrity of the Republic of Ghana, and that I will truly and faithfully perform the functions of my office without fear or favor, affection or ill will. So meaning that you are not supposed to show partiality in any way when it comes to application and enforcement of the law. Another core element is legal certainty. Law should be clear, publicized, stable, and applied evenly. And that is why we have a whole constitutional provisions on how to make laws. You take Article 106, for example, we have a various procedures together with the standing orders in Parliament. And we take Article 11, Clause 7, how to make a delegated legislation or statutory legislation, all have been specified. And the point is to have legal certainty. Then there should be procedural transparency. Procedural transparency, processes by which laws are enacted, administered, and enforced should be open and transparent, and that should allow for public scrutiny and participation. So people should know how laws are made. People should know and understand how laws are enforced. So for example, if you have a case against someone or the case against the state or any governmental agency, you should have the foreknowledge of the processes and procedures which you have to be gone through in order to get the case adjudicated. But rule of law, as we've indicated in the opening, is contested. Contested in the sense that it is subjective. That is to say that it means different things to different people and societies. And that can be quite challenging to define because we have varied interpretation. Various philosophers, legal scholars, practitioners from different backgrounds will have different theories and models of rule of law, and they will emphasize different aspects of it. So you can have, for example, a regime which is not constitutional democracy, and yet they could be making noise about the rule of law. Another difficulty accounting for this subjective or contested concept is the cultural differences. Those of us in Ghana, we have our various cultural, our historical backgrounds, and that also applies to other jurisdictions. And all these cultural differences could shape how we seek to understand rule of law. Then we also have various and divergent political ideologies, different political systems, liberal democracies, authoritarian regimes, and they may interpret rule of law in a way which conform or align with their governance models. So if you go to a country where you have like a military junta, they could be making a lot of noise about rule of law and say that everything should be done according to the laws of the country, the decrees they make and all that, and they are talking rule of law. So that is it. But rule of law can be seen in rare action, in practical manifestation. So supremacy of law over arbitrary power, where we have that, then we can see that rule of law is at work. That those who wield power cannot just act anyhow. Their power should be subjected to the dominance or the supremacy of the law. And this is very important as it gives important protection against tyranny and abuse of power. Another practical manifestation is when we have government under law. The government itself is subject to law. It must act within legal framework established by the Constitution and statutes. And for that matter, if we take Ghana, our Constitution, for example, Article 1, Clause 1, we say that sovereignty of Ghana resides in the people of what? Of Ghana, in whose name and for whose welfare the powers of government are to be exercised. The powers of government are to be exercised in the manner and within the limits laid down in this Constitution. Meaning that, yes, we are going to set up a government, but those who are going to wield governmental powers, they are not going to exercise it in vacuum. They are going to exercise it within the parameters, within the framework set by the 1992 Constitution. When we have separation of powers, it's also manifestation of rule of law, where government is divided in separate branches, as we'll be discussing previously. You have the executive, legislature, and the judicial. And the point of separation of powers in relation to rule of law is that no single entity has unchecked power, because if the powers of governance are located, and meaning that we can have checks and balances, and that to promote accountability and prevent abuses. Again, a practical manifestation of rule of law is where we have independent judiciary, where the courts are independent from political influence and able to adjudicate disputes impartially and uphold the law without fear or favor. And this without fear or favor, I'll give you a practical example. There are times that the courts, you give a judgment, and according to your understanding of the law and the evidence, that is how it should be. But in your heart, you may feel sorry for the losing party, but you cannot do anything about it. So that is you upholding the law without fear or what? Or favor. You cannot favor the person who even is seen as the weaker person. If your case is good, it's good. If your case is bad, it's bad. It doesn't matter whether you are weak, you are strong, you are rich, or you are poor. So that is the point about impartiality in adjudication. And that is possible while you have independent judiciary. Another manifestation of rule of law is the access to justice. Access to justice. Citizens must have the ability to seek justice. Ambrose, I'm teaching online. I'll call you back. Bye. Yeah, so having understood ways in which rule of law can be identified, as somebody said, I may not be able to define the elephant, but when I see one, I can say that this is the elephant. So in the same vein, even if we are not able to produce a foolproof definition of rule of law, we have armed ourselves with certain indicators which will help us to recognize whether rule of law is present or absent. So let us keep that in mind. So we want to look at how the concept of rule of law has evolved, the historical evolution of rule of law over the ages. So we'll start from the ancient civilizations. We can go back to the code of Hammurabi from the Babylon and later on Mesopotamia. And this code of Hammurabi is one of the earliest known set of written laws, where laws were systematically written down. And this thing we are talking about almost 2,000 years before the time of Christ. So that should tell you that we are talking almost about the 4,000 years plus now. And the Hammurabi Code established rules and corresponding punishments. And the aim was to provide justice and order. So the importance of or the learning which we gain from the Hammurabi Code as far as rule of law is concerned is that they wanted to avoid arbitrariness. So they define what is expected of members of the society and what is not expected of them, and what the consequences, what the sanctions or the punishment will be if citizens do what they are not expected to do, or if they fail to do what they are expected to do. So that is very important. And that is an evidence that they were working towards a system which will eschew arbitrary rule, which will avoid arbitrariness. Arbitrariness in the sense that decisions are taken, actions are taken anyhow without predetermined rules. Now, if you come down to ancient Greeks, of course, when we are talking about Western democracy and most of the concepts, we owe a lot of things to the Greek civilization. And if you take Athens, for example, what they call democracy, if you know the Greek word demos kratos, that is the rule of the people, where the people selected maybe their representatives and they meet, deliberate, make laws, and then they will rule the society. And within that context, we have people who studied how democracy in Athens was functioning. And the thinkers at the time, Socrates, Plato, Aristotle, having observed how society was functioning, explore concept of justice, law, and governance. So, for example, if you take Aristotle will make the point that it is more proper that law should govern than any one of the citizens. So in Aristotle's writings, he will emphasize the necessity of governance of law over governance of people. In other words, we should be ruled by laws rather than by people. So he advocated for the supremacy of law over the whims of rulers and emphasized that law should guide the actions of both the governed and the governors. So all of us are ruled by law. So that is the point. And this goes back to nearly 400 years before the time of Christ. Then after the Greek civilization, you also have the Roman civilization, the Roman Empire. And we also get useful lessons regarding how the idea of rule of law evolved. So, for example, Cicero, the celebrated Roman lawyer, great advocate, and the publicist, in his various writing, the Legibles, the Republica, and all the various writings that he did, he upheld the sanctity of law. In other words, that the law is sacred. The law is sacred. And he made the point that the obedience of law was essential for the stability of the state. Obedience of law is essential for the stability of the state. And again, there was an empire called Emperor Justin, and when he became the emperor, he commissioned scholars to produce what we call the 12 tables. And in your legal system and legal method, when you are learning about the civil law tradition, I'm sure you have come across the 12 tables. And this was, if you like, the Rome's first code of law, which was made public for people to know the law, which they were supposed to obey or have to govern their life and their affairs. Yes, now, did somebody hand us up? All right, there's someone there. Now apart from these ancient civilizations, we also come to the medieval period, especially the English society. We have heard of the Magna Carta. Yes, now you can talk. Now you can talk. Your mic is released. Your mic is released. Yes.
So it's just a mistake.
All right. Yeah. So going back to how the early English society also contributed towards the development of what we now call rule of law, we can point to the Magna Carta, that great document adopted in the 13th century. And as we have met it before in constitutionalism, separation of powers, and all that, it was a charter, an agreement, a solemn agreement, so to speak, between the king, King John of England, and his barons to limit royal authority, to give certain concessions to the governed. And if you look at it, some of the salient provisions were that no free man would be imprisoned or punished without a lawful judgment by his peers. So meaning that right from the day of Magna Carta, there was a conviction that a person cannot be detained, imprisoned, or punished without having been tried and having properly been convicted, as it were. And of course, that also points to the beginning of like a jury trial, by his peers. Then the king also agreed to abide by the law and acknowledge that his will was not arbitrary. Yes, you are the king, but once the king in parliament, laws have been made, the king will have to obey the law, except where he gets his parliament to change the law. So this Magna Carta established a very important or salutary principle that everyone, including the monarch, be it the king or queen, depending upon whether the monarch was a male or female, is subject to law. And this Magna Carta is considered a very foundational document for various constitutional efforts. So if you look at the Rea Akoto, if you read the full judgment and submission by the lawyers, you notice that they will have even alluded to the Magna Carta copiously in their submissions. Now, beyond the Magna Carta, there are other important efforts in English history pointing to the development of rule of law. For example, Lord Edward Coke, as far back as the 17th century, in his writing, will assert supremacy of the common law over the monarch. And the occasion for him to make this assertion was the famous case called the case of Dr. Bonham. Dr. Bonham's case, very famous case. And in that case, he argued that even if the king is subject to God's law, that even the king is subject to God's law, meaning that the king is not omnipotent, the king is not above the law. The king is subject to God's law and the law of England. And that was quite important. And similarly, the case of Entick and Carrington in the early part of the 18th century, we have a gentleman called John Entick, who was a writer and publisher. And he was suspected of seditious libel against the government. Of course, you remember that during President Kufuor's reign, the seditious libel law was repealed in Ghana. A criminal libel was repealed in Ghana. So in the Entick's case, the agents of the crown, that is the monarch, acting under general warrant issued by the Secretary of State, who was Lord Halifax at the time, forcibly broke into Entick's home, John Entick's home, conducted a search and seized papers which he was alleged to have published against the government. So John Entick sued for trespass and put up the argument that the seizure and the search and the seizure upon his home were illegal because there was no specific legal authority for the warrant. In his view, general warrant was not enough. And the courts, led by the Chief Justice at the time, Lord Camden, will take the view that the warrant under which Entick had his home broken through and searched and items seized was illegal and void. And the court held that the government officials could not interfere with the private property without explicit legal authority. Without explicit legal authority. And later on, if you reflect on the decision in Entick and Carrington, there is a principle we call eminent domain. The exercise of eminent domain, what we call compulsory acquisition. So if you look at Article 20 of the Constitution, it provides a framework that if the state needs anybody's property for the national interest, something which is for the good of the whole society, then the state must go through certain procedures, including payment of adequate, fair, and prompt compensation to the affected individual whose private property is being compulsorily acquired. So all those ideas go back to the common law approach as reflected in Entake and what? And Carrington. And if you look at the Entake and Carrington decision, another significance or what it teaches us is that government is subject to law and cannot exercise power arbitrarily. So if you take various constitution, US, for example, originally they didn't have in their constitution. It has to take their fourth amendment, which provided that you cannot conduct search and seizure without appropriate legal authorization. In the same vein, if you come to our constitution, we have the protection of private property. And that is why if you look at even the modern law and the Terrorist Act and the various legislation, they may have to go to court or go to appropriate authority and get authorization, even if without the knowledge of the person whose house is going to be searched. But at least there will be some kind of check so that that person's right is not arbitrarily abused, as it were. Now, various scholars have also reflected on the concept of rule of law. So we'd like to explore some legal theorists or scholars who have made important contribution in illuminating our understanding of the concept of rule of law. And there's one particular scholar, as soon as you mention the concept rule of law, it's like synonymous with his name, A.V. Dicey. A.V. Dicey did a major work called Introduction to the Study of the Law of the Constitution. And he articulated the modern concept of rule of law in the English legal system. So what were the three principles of rule of law which Dicey in his work of the 19th century articulated? One, that no punishment without law. So Dicey thought that individuals can only be punished for breaches of the law established in a legal manner before the courts. The law must be clear and publicized, providing individuals with knowledge of what constitutes illegal behavior. And mind you, what Dicey taught has found its way into various documents, including Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, and also our own constitution, fair trial rules. If we look at Article 19, the fair trial rules. Now, part of Dicey's teaching that there should no punishment without law also means that retroactive laws, that is ex post facto. When we say ex post facto, that is after the fact, or this one, something has happened, and then you make a law you predate the law, or you let the law go back into the past to govern things which have already happened, to make them illegal. So that is retroactive laws are generally prohibited because they punish individuals for actions that were not illegal at the time they were committed. And if you take Article 19 of our Constitution, all these are reflected there. So Article 19 of the Constitution, all these are reflected there. And I've told you, despite the fact that we are teaching online, when we are teaching, you are still required to be taking notes because not everything that we have in the notes or the slides. So if you look at the case of Shaw against the DPP, for example, Shaw published a directory of prostitutes. Now, when he published the directory of prostitutes, there were no specific laws which prohibited that. So he was charged with conspiracy to corrupt public morals. Now, the House of Lords upheld his conviction and recognized the existence of common law offenses that protect public morality. There's something called common law offenses. These are offenses which have not been defined in any particular law, but just through various judicial decisions. But if you look at our Constitution, we have explicitly prohibited or abolished what is known as common law offenses. The only common law offense, so to speak, which is actually safe, is what we call contempt of court. Apart from contempt of court, nobody in Ghana can be charged or convicted of any offense which has not been spelled out in a written law with the punishment already prescribed. So Shaw and DPP, for example, illustrate the tension between the principle of legality and also judicial creativity in recognizing new offenses. But thank God, this is not a problem we have in Ghana because of Article 19 of the 1992 Constitution. Another teaching from Dicey's writing is equality before the law. So the first one, he said no punishment without the law. Now he's talking about equality before the law. And by this, Dicey meant that all individuals, regardless of status, are subject to the same laws and the same courts. So we shouldn't have special laws or special courts for different people. And no one is above the law, including the government officials and the wealthy. So, where legal privileges are based on a status, they are incompatible with the rule of law. And this is important. If you are a member of parliament in Ghana and you are alleged you have stolen, arrested, you'll be arraigned before the same court, which a common, let's say, liberal, so to speak, that's for sake of discussion, would also be arraigned before if he or she is also alleged to have stolen. We don't have special courts or special arrangement for different people. If you are a judge and you have violated the law, the same court that you sit, which ordinary citizens are arraigned before, is what you also be arraigned before. So there is equality before the law. So there's this case in the UK called the A. Ray M. And the Home Secretary ignored a court order to return an asylum seeker who had been unlawfully deported. The court took the view that the government official could be held in contempt of court for failing to comply with judicial decisions. And we see this all the time. There's a point in time in this country when the IGP was cited, and I didn't follow through if he was even held for being in contempt of court. Now, at common law, we have rights and freedoms which are secured by the common law. And that is also part of the teaching of Dicey, that individual rights and freedoms are best protected through judicial decisions rather than written constitutional bill of rights. But that one is controversial as to whether it is better to leave rights and freedoms of the individual to be elaborated on case-by-case basis by the court, or you should have a law, just like we have the Bill of Rights, like Chapter 5 of our Constitution, spelling out the freedoms and then the rights, so that everyone knows what is protected by the law, rather than leaving things to be worked out by the court. But of course, we still have that when it comes to the law of tort. Later on, when you are learning law of tort in the second year, if you are not learning it now, you notice that the law of tort, by and large, protects so many interests and rights, which are not necessarily founded upon the Bill of Rights, as in the constitutional chapter on fundamental human rights and freedoms, or the Human Rights Act, if you are talking about, let's say, UK. But the courts determine and enforce them when the right set of facts are presented before the courts. So especially when it comes to negligence, the duty of care, the court will say that somebody owes you a duty of care to ensure that his actions or omissions will be mindful of you, and that if he's not mindful of that and they cause you injury, then you'll be made to compensate you. So, as to whether duty of care exists or not, the courts have just come out with general principles, and then on case-by-case basis, they will determine whether in a particular set of facts, the duty of care exists or does not exist. Yeah, so that is the right secured by common law, but there's a difficulty, because if you rely solely on the common law, we may have certain rights which are not properly protected. So it is better to have a formal codification like what we have now. And of course, Dice's contribution on that has actually not gone down well with society over the ages. And that is why we have various bills of rights. The Human Rights Act, you go to UK, the Human Rights Act of 1998. Ghana, we have our 1992 Constitution, Chapter 5. Then various countries have their Constitutional Bill of Rights. But it is better to have rights actually spelled out in the bills of rights as we have, than to just leave it hanging to be determined on case-by-case basis by the courts. Now, apart from Dicey, we also have other thinkers like Joseph Raz. Joseph Raz also talk about procedural or formal approach to rule of law, and also substantive approach to rule of law. So Joseph Raz emphasized that rule of law is primarily concerned with the way laws are made and enforced rather than their content. So he was concerned about how laws are made and not necessarily what the law says. Of course, later on when you are learning legal philosophy or jurisprudence, you come across another scholar called Longfuller. Longfuller will discuss what we call procedural natural law. And his ideas are very similar to what Joseph Raz is saying, that the procedure by which the law is made is as important as the content. So we shouldn't just be interested in whether what the law is saying is good or bad, it's just or unjust, but what processes or what procedure did we go through to get the law fashioned or made. So he proposed 8 principles that focus on legal procedures, clarity and function of legal institutions. And as I've said, these ideas are also very similar to what Longfuller also teaches. So what are Joseph Rice's 8 principles? One, clear prospective laws. That is to say that laws should be prospective, not retroactive. No, retroactive means that letting the law, backdating the effect of the law. So make a law today, and you let the law govern things which happened before today or before the law was made. So that is retroactive. So he's saying that law should not be retroactive. Law should be prospective. Law should be open and clear to guide individuals' behavior. And of course, we remember the flips against the I case, where the court will make the point that retrospective legislation is generally discouraged because it undermines legal certainty. Another principle which Ras talks about is stable laws. That laws should be relatively stable. That laws should be relatively stable to allow individuals to plan their actions accordingly. Then he also talks about open lawmaking. The process of making laws should be transparent and guided by established rules. He also talks about independent judiciary. Courts must be independent to ensure impartial adjudication. We've explained that before. And then the 5th point Ras talks about natural justice. The legal procedure should observe principles of natural justice, including the right to a fair hearing. So after rule of law, we will discuss natural justice as our very last topic after judicial review and independence. And natural justice basically talks about the fact that there should be fairness when it comes to decision-making or adjudication. If you are going to settle a dispute, give equal hearing to the parties. Avoid bias or avoid partiality or favoritism. So we have the natural justice rule of audi alteram partem. Audi alteram partem, that is, hear both sides. You must hear both sides of a matter before you decide. You have to give fair hearing. And you also have the natural justice rule of nemo iudas in causa sua. Nemo iudas in causa sua. The natural justice rule against bias, that no one shall be a judge in his own cause. You cannot be like a referee and a player. As a general rule, there are exceptions where the statute imposes a duty on someone. If that person is even involved in the dispute, but he is the one who have to set up the court, like the Chief Justice. You see the Chief Justice under the Constitution is the one who is supposed to determine which judge sits on which case, or which case goes to which court. So this is a constitutional duty. So therefore, the natural justice principle of nemo iudas in causa sua, or you shall not be a judge in your own cause, or for example, be sidestep when it comes to that limited scenario. The 6th point, which Joseph Rice talked about, is judicial review of administrative actions. The courts should have the authority to review the legality of administrative decisions. So if you look at Article 24, right? Article 24 of the 1992 Constitution, for example. Article 24 talks about administrative justice. No, is that Article 24? No, sorry, Article 23, not 24, sorry. Article 23 of our Constitution talks about administrative justice. Quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. Yeah, so that is exactly what the Joseph Rice is talking about. The court should have the authority to review legality of administrative decisions, and the court will usually use the prerogative writs, habeas corpus, mandamus, quo warranto, certiorari, prohibition. So those are what the court will use to ensure that administrative decisions or administrative bodies act fairly and reasonably. Then the 7th point Joseph Raz talked about is the accessible courts. That the judicial system should be accessible and justice should not be denied due to excessive costs or delays. So where the courts are not accessible, according to Joseph Raz, you don't have rule of law. Or where justice is expensive, you don't have rule of law. Justice should not be expensive. And of course, that is why we also have even the Legal Aid Commission to provide legal representation for impecunious litigants, as it were, or indigents. Then he also talks about limited discretion. Now, discretionary powers of law enforcement and administrative agencies should be controlled to prevent arbitrary decisions. And this is very important. And that is why we have the prerogative raised there. For example, to ensure that the police cannot arrest you anyhow, we take our constitution. We have the rules of lawful arrest. Your personal liberty is what? Is guaranteed. So the constitution will say that if you are arrested, you shall be told, look at if you're arrested, you shall be told the reason for your arrest immediately. Look at the 14 of the Constitution. A person who is arrested, restricted, or detained, 14.2, shall be informed immediately in a language that he understands the reason for his arrest, restriction, or detention, and of his right to a lawyer of his choice. Now, where that is not done, you can go to court and challenge it. And if you are successful, the state will have to compensate you. And there are so many cases in which people have been compensated for violation of their right to personal liberty. We also have Ronald Dworkin. Ronald Dworkin, later on when you're doing jurisprudence, he will talk about substantive approach. Now, he did a very important work. And the work that he did, the Law's Empire, and then the right answer thesis, and then the morality of law. So he will make the point that the rule of law must encompass moral principles and protect fundamental rights. And by this, Dworkin meant that law should not only be enacted properly, but must also be just and respect individual rights. So he will develop the concept of the law as integrity. So by law as integrity, Dworkin will be telling us that judges should interpret he will tell us that judges should interpret laws in the best moral light and consider principles of justice and fairness. So there's something you call hard cases. If later on when you're doing jurisprudence, you learn more about that. So by hard cases, Dworkin will be making the point that even if judges are confronted with a case in which there appears to be no direct precedent, that is, there's no previously decided case, which is relevant to that case, it is still expected that the judge will be able to come out with a decision which aligns with the underlying values of the legal system, which the judge, by his training, has actually been exposed to. Then he talks about right as trumps, that individual rights should prevail over collective interests when conflict arises. In other words, the state, or we should not rush to elevate collective interests over the right of the individual. Now, we also have Sir Ivor Jennings, a very respected constitutional lawyer. He provided a critique of former legality. And Sir Ivor Jennings warned that strict adherence to legality without substantive checks will still result in tyranny. In other words, if we reduce rule of law to just having a law that, yes, what is being done is according to law. If that is our basic understanding of it, then according to Ivor Jennings, we are making a mistake, because you can get a tyrant, you can get a tyrannical government, just like Adolf Hitler's Nazi Germany, where they'll put in place all laws. Everything which is being done is according to law, and yet you will not have rule of law. If rule of law is supposed to safeguard the liberty, then that will not be there. So Ivor Jennings warned against strict adherence to legality without substantive checks. And for that matter, Ivor Jennings will emphasize the need for constitutional restraint. So that is, there should be constitutionalism, that is constitutional restraint, separation of powers, and protection of individual rights in order to avoid abuses. So if you look at his work, there's a famous quotation associated with that Sir Ivor Jennings, that strict adherence to legality is no guarantee against tyranny. Strict adherence to legality is no guarantee against tyranny. And it is true. You can have a law which says that let's kill all short people, or let's kill all people who cannot hear, deaf. Yes, that is law. But is that what rule of law is supposed to achieve for us? So strict adherence to legality is no guarantee against tyranny. Well, there have also been another cynical way of looking at rule of law, and that comes from Karl Marx. You might have heard of Marxism. Karl Marx developed the idea, which is associated with called the Marxism, or the Marxist theory. And Marx's view is that law is instrument of class domination. That is, the upper class, what you call the bourgeoisie, the powerful in society, they hide behind law and say that, yes, there should be law, there should be rule of law, everything should be according to the law. But in Marx's view, the law becomes just a facade. It just becomes like a cover to mask the systematic exploitation of the proletariat, the masses, the ordinary people. Of course, who are those who make laws? Marxists will say that is the powerful, the bourgeoisie. and then they will make the law to serve their interests. And once the law is reflecting their interests, they can hide behind the law and say that everyone should be under the law. Everyone is under the law, but ultimately, when the law is analyzed strictly, it is serving the interests of certain few people. And that is why they say that the law is an instrument of class domination. So if you look at Marx's view, then rule of law becomes a suspect. Because rule of law is the idea that you want government by law, that the law should rule everyone, both the governed and then the governed. But if it is a case that the law is not really serving interests of the entire society, but serving just the interests of some powerful people, the bourgeoisie, as against the proletariat, then what is the point of talking about the rule of law? So these are some of the challenges which we have. So, for example, if you are interested, if you read the Animal Farm, George Orwell, provides a satirical commentary on socialist society, which seeks to draw inspiration from Marx's view. You remember the Animal Farm story, how Mr. Jones was eventually overthrown by the animals, and then the animals decided to set up their own kingdom. And the very things that they've accused the human being of exploiting them, the animal leaders who led the revolution in no time started also behaving like the human leaders. So it became like a cyclical. So George Orwell was trying to ridicule the idea of Marxism as reflected in socialism. Well, if you also go to other cultures, especially the Far East, the Far East, the Oriental, that is the Chinese and all those Asian places, they have a different view concerning rule of law. Over there, there's a preference for social harmony. So some of their ancient philosophers, such as Confucius, you might have heard of a Confucianism. He will emphasize harmony, social order, and mutual respect over formal legal mechanisms. So in the Oriental society in the Far East, reliance on formal law is viewed as a sign of societal failure to maintain moral order through relationship and virtues. Of course, these are just ideas which are out there, but you notice that in the modern world, rule of law has come to stay, and there are various international initiatives which have been made to try and get a blueprint or some consensus on what rule of law actually represents. But as students of the law, we need to be aware of this broader context and then the various ideas which are out there and the historical trajectory which the concept has actually followed. I think there are some hands. Let me see. Okay, so yes, Eli Kojo Abocho, you've read it. 4 less good. 2 less better. Oh, somebody said the presentation is not being shared. Really? Is it the case that you cannot see? Can you see the screen? Because I'm sharing from my end. All right. Now, let's come to contemporary elements or contemporary understanding of rule of law. How is rule of law interpreted in modern times? We will start from the United Nations. The United Nations, the organization International Organization for Civilized States, which emerged after the end of the Second World War to try and work towards international peace and security. So the United Nations views the rule of law as essential for the protection of human rights, sustainable development, and maintenance of international peace and security. So if you look at the UN Charter, for example, you get reference to rule of law. And then the rule of law is actually expected to be a better means of protecting human rights, driving development, and also maintaining international peace and security. Now, in 1948, that is 3 years after formation of the UN, 1945, in 1948, we had the Universal Declaration of Human Rights. The very first time that nation states had come together to say that if all of us agree that we are human beings, regardless of our color, regardless of where we are coming from, regardless of the circumstances of our birth, then we need to recognize that there are certain rights and freedoms which all of us should enjoy, and no one should be deprived of that. Now, those convictions were expressed in a document which you call the Universal Declaration of Human Rights of 1948. And in that document, the rule of law, if you look at the preamble of it, rule of law is emphasized as a foundation for human rights. Now, there is a body which is called World Justice Project, WJP. I'll put the website there for you. And the World Justice Project is an independent multinational organization founded in 2006 by William Nukin, who was the president of the American Bar Association. Now, this body, which was set up, well, not too long ago, 2006, recognizes that rule of law impacts everyone. It's not just legal professionals. And for that matter, the World Justice Project adopted a multidisciplinary approach to rule of law in order to reduce corruption, combat poverty and disease, and protect people from injustice. I would like you to visit their website, just click on it and just familiarize yourself with it. And the World Justice Project espouses 4 universal principles as far as rule of law is concerned. 1, accountability. And by this, they mean that the government, the private sector, and individuals are accountable under the law. Then 2, just laws. The laws are clear, publicized, stable, and applied evenly in order to protect fundamental rights. And then the 3rd principle is that open government, processes by which laws are enacted, administered, and enforced are accessible and fair. And then the 4th universal principle they talk about is accessible and impartial dispute resolution. So justice is delivered timely by competent, ethical, and independent representatives. So these are the 4 universal principles of rule of law, according to this World Justice Project. And you notice that these four universal principles they talk about, they are not new. They are just extraction from the various ideas which have evolved over the ages, which we'll be discussing. They have something they call the Rule of Law Index. So the Rule of Law Index is an annual report evaluating countries based on these principles, which we have talked about. These universal principles: accountability, just laws, open government, accessible and impartial dispute resolution. So I'm going to share the report with you so that you know where Ghana fits as far as their Rule of Law Index is concerned. I'm going to show that with you. That's why I'm opening that document. And so this is the word that says project. They have, I hope you can see what I'm saying. They have what you call the World Justice Project Rule of Law Index. Can you see? Just type yes in the chat if you can see. Okay. Yeah, so they have the 2024. I want us to check where Ghana fits. I'll put it on your platform. You can just look at it. So go to page 13. You notice they have provided what we call the definition of the rule of law there. You can look at it. I think this is, let me do the distance so that I can see clearly. Yeah, let me rather use this. Good. Yeah, so this is their report. The World Justice Project Rule of Law Index 2024. I'll put it on your platform. You can look at it. So the four universal principles of rule of law talk about, they discuss it at page 14. The attendant provide definition of rule of law at page 13. But that's not very interesting. I want us to look at where Ghana is. Good. So this is the report overview of overall scores and rankings. So the table below shows overall scores and rankings of World Justice Project Rule of Law Index 2024 in alphabetical order. Scores range from 0 to 1, with 1 indicating the strongest adherence to the rule of law. So if you get 1, meaning that thumbs up for you, you're doing very well on the rule of law scorecard, as it were. If you get 0, it means you are not doing well. If you get negative, then it's very disappointing. So let's look at the country. We are interested in our country, Ghana. So, but if you look at the table, you notice that they have the country jurisdiction, they have like the overall score. So the overall score, that is the 0 to 1, where do you fall? And then they will try and look at the last time they did it, the last year and now. What is the change in overall score? Then they give you, if we are to rank you globally, like the countries in the world, if you are to rank ones which are doing very well in terms of rule of law, what will be your position? And then we also have change in global rank. Like the last time they did the league, and now has your position changed or your position is the same? So that those are the parameters we should understand. So on that basis, so if you look at the country like, of course, Afghanistan, they are ranking 140, so they are doing really bad. And the overall score is 0.32. No, sorry. Yeah, they rank 140 the whole world, yes. But let's look at Ghana and probably one or two African countries. Let's look at Nigeria. Nigeria is here. So Nigeria, the 0 to 1, they made only 0.40. And their position, they are ranking 120. So their global position 120, which is really bad. So if you take, let's say, how many countries? I think about 140 countries or something. Or some, yeah. And they are ranking 120. So let's take Ghana. Ghana is here. The 0 to 1, we are 0.55. And we are ranking 62. It's not the best, but at least we are doing better than Nigeria, isn't it? Our global rank is 62. Now let's look at the South Africa. South Africa. South Africa, they rank 57. Ghana, so at least Ghana is 3. I think we are 60, if I'm not mistaken. So Ghana is 3, no, we are 62. Ghana, we are 5 steps behind South Africa. We are 5 steps behind South Africa. Let's look at some of the big boys, some of the big countries. United States. So 0 to 1, United States, they are doing 0.7. And they rank 26. So they are ranked 26 in the world. United Kingdom, they are 15. They are positioned 15th in the world. There's a country which is ranking number 1. I think is one of these. Yeah, if you look at Norway, for example, Norway, their position is number 2. So the 0 to 9, they are 0.89, so they're almost there. So they are the second in the world as far as rule of law performance is concerned, according to this assessment. Okay, so you have an idea. Later you can look at it on your own. So if you look at the, they provide how they understand the rule of law. So for them, you understand the definition of rule of law is effective rule of law reduces corruption, combat poverty and disease, and protect people from injustice, large and small. Then traditionally, the rule of law has been viewed as a domain of lawyers and judges. However, everyday issues of safety, rights, justice, and governance affect us all. So everyone is a stakeholder in the rule of law. And they will try and provide. Yeah, so you look at it later on when you get it. But look at the universal principles of the rule of law they identify. Accountability. So universal principle 1 is accountability. Universal principle 2 is just law. And then the 3, grouping government. The 4th one is accessible and impartial with justice. Then they will try and explain. So they have various sub-factors. So factor 1, constraint on government powers. Government powers are effectively limited by legislature. Government powers are effectively limited by the judiciary. Government powers are effectively limited by the independent auditing and review. Government officials are sanctioned for misconduct. Government powers are subject to non-governmental checks. Then transition of power is subject to the law. So that is one factor. Another factor is we have 44 sub-factors, you can imagine. So absence of corruption. Government officials in the executive branch do not use public office for private gain. Government officials in the judicial branch do not use public office for private gain. Government officials in the police and the military do not use public office for private gain. Government officials in the legislative branch do not use public office for private gain. Then factor 3, open government. Publicize laws and government data. Right to information, civic participation, complaint mechanism. Factor 4, fundamental rights, equal treatment and absence of discrimination, the right to life and security, and also on they are all listed there. Factor 5, order and security. Crime is effectively controlled, civil conflict is effectively limited. Factor 6, regulatory enforcement. Factor 7, civil justice. Factor 8, criminal justice. Yeah, so later on, you can look at it if you are interested and learn more about it. Now, just before I close this one, let me take the opportunity to open this one and show you. We are going to talk about this. We talk about, at some point of the class, we talk about this, the International Commission of Jurists. They have important congress they did in 1959. And they had what called the rule of law in a free society, what is known as the Delhi Declaration of 1959. So I'll put this document on your platform so that if you are interested to deepen your understanding, you will run your eyes through it, because the International Congress or Commission of Jurists, their meeting they did in 1959 and the document they issued is a very important landmark regarding emerging international consensus on what constitutes rule of law. So let's go back to our presentation. Okay, so we are looking at the modern understanding of a rule of law. So if you look at the UN, you've talked about the Universal Declaration of Human Rights and the fact that it sees a rule of law as very important in protecting human rights. Then we've also mentioned the work of the World Justice Project and their rule of law index they've been doing. So the International Covenants on Civil and Political Rights, which was adopted by the UN, is a very important binding human rights instrument after the Universal Declaration. When Universal Declaration is just a declaration, it wasn't really binding. And in that ICCPR, it provided legal protection for various individual rights, what you call the civil and political rights. And later on, there will be International Covenant on Economic, Social, and Cultural Rights. Now, if you look at modern constitutions too, there are constitutional provisions which incorporate Bill of Rights to safeguard fundamental freedoms. So if you take our own constitution, Chapter 5 of our constitution, and not only Chapter 5 of the 1992 constitution, if we take the 1979 constitution, there was a Bill of Rights in it. If we take the 1969 constitution, there was a Bill of Rights in it. The 1960 constitution, the least said about it, the better, because of the unfortunate decision of the Supreme Court in Ray, Akoto, and 7 others. Now, Lord Bingham gave important lecture, which was published as a book the rule of law, 2010. The letter was in 2006, but eventually published as a book in 2010. So Lord Beham attempted to articulate contemporary or modern understanding of rule of law. So he canvassed the following point. He talked about accessibility and clarity, and by this, Lord Beham meant that talking about rule of law, then law must be accessible, insofar as possible, intelligible, clear, and predictable. Then he also made the point that rule of law, we are talking about law, not discretion. So questions of legal right and liability should be resolved by application of law, not the exercise of discretion. In other words, as far as possible, discretion should be used sparingly, or if possible at all, there shouldn't even be room for discretion. But except that that is not practically possible, it should be used minimally. Then he also talked about equality before the law. We explained that already, that the laws of the land shall apply equally to all, save to the extent that objective differences justify differentiation. And later on, in Ghana, you look at the some Supreme Court decisions in which they will say that, yes, if you look at even Article 17 of the Constitution, it tolerates a certain amount of, if you like, positive discrimination, as it were. Then another point he canvassed is exercise of power. The public officials must exercise powers in good faith, fairly, and for the purpose for which the powers were conferred. So when you're a public official and you have certain powers under the law, use the powers properly for the purpose for which the power was conferred, and not for any ulterior motive, as it were. Then he also talked about human rights protection, that the law must afford adequate protection of fundamental human rights. So all these things, Lord Beham, just like others, is trying to give his blueprint of rule of law. In other words, how can we say that there's a rule of law? In his view, when these matters are there, then rule of law is at work. Then dispute resolution, and that means must be provided for resolving dispute without prohibitive cause or inordinate delay. So in modern times, we have the traditional adversarial litigation. We also have what we call ADR, alternative dispute resolution mechanism. So even if people do not have the time, the money to go to the courts, there's opportunity for you to go to any person that both of the disputing parties believe in his judgment, his impartiality, to listen to them and help them to resolve the matter, either by mediation, arbitration, or as it were. And once that is done, the outcome can be enforced through the court processes. Then you also talk about fair trial, that adjudicative processes provided by the state should be fair. And then he also talk about, of course, a fair trial. You don't need to belabor that point. If you look at that Article 19 of our Constitution, Article 19 is one of the longest provision in the Chapter 5. Then Lord Beham also talk about compliance with international obligation, that the rule of law requires the state to comply with its obligations in international law, because once you are a responsible state, you have ratified or convention or treaties or charters, as it were, you must live up to your obligation under it. just as you expect within your municipal system, the various laws will have to be obeyed by everyone, including the state itself. The same thing applies to the state's international obligation. Yeah, so if you look at the Lord Beham's formulation, you notice that he combines both procedural and substantive elements and makes the point that human rights and justice are important in talking about any meaningful framework for rule of law. Now, apart from that, we also have other international, like the EU. If you take the EU, for example, the EU, they have what they call the Copenhagen criteria, that if you are a European country and you want to be admitted into membership of European Union, you must have stable institutions which guarantees democracy, rule of law, human rights, and respect for and protection of minorities. So the point here is that rule of law is an important component of Copenhagen criteria, which European countries who are not members of the European Union seeking to become members must meet before they will be admitted. So it tells you how rule of law is what is important. Again, the EU, they too, monitor, they have a system of monitoring member states' adherence to rule of law. And where they observe that a member state is not abiding by rule of law commitments, they can initiate proceedings against those violating the EU principles. Then you come home, African Union, we took over from the OAU, Organization of African States, the AU. If you look at the constitutive instrument, that is the treaty or the charter, which set up the African Union, if you examine it, it promotes principles of democracy, human rights, and rule of law among member states. You can just Google AU constitutive instrument, and then just look at the preamble, and you can tell whether what I'm telling you is the truth or not. Yes, it's also emphasize the principle of rule of law among members. And of course, the African Charter on Human and People's Rights, adopted in 1981, also emphasized protection of rights and adherence to rule of law. So the point being made is that rule of law has been evolving over a long period of time. And at the international stage, as we have seen, and in modern constitutional system, rule of law has made this way. So the point in terms of application of rule of law to constitutional law is that, first of all, rule of law is the foundation of constitutionalism. I mean, without rule of law, there's no need of constitutionalism, because we are talking about supremacy of the Constitution. Rule of law says that the law is supreme, isn't it? So supremacy of the Constitution. So Ghana, we have no problem. If you look at our Article 1 and Article 2, the doctrine of the supremacy of the Constitution is the highest law, and all laws and government action must conform to it. So limitation of government powers. The Constitution delineates powers of different branches of government and include checks and balances to prevent abuse. So we see all this in modern constitutions, how rule of law is actually deployed in modern constitution. Protection of rights. So constitutions often enshrine fundamental rights and freedoms, which safeguard them from infringement. So if you come back to our own constitution, we talk about chapter 5. So we look at some constitutions. We have what you call like the bill. When we say Bill of Rights, let me just make the point. Bill of Rights simply means that you have like a comprehensive legal treatment or legal guarantee for fundamental human rights and freedoms. So the common practice in most modern democracies that have constitution is to get their constitution devoting a whole chapter or a couple of chapters in talking about various rights and freedoms that have been guaranteed for the citizenry. So that's what we call like the Bill of Rights. But of course, if you take countries like say United Kingdom, they don't have a single written constitution. So they have what we call like the Human Rights Act when they sign up to the European Convention on Human Rights. But apart from them, in most other jurisdictions, including our own, we have like a Bill of Rights, which is a part of our constitution and which provide explicit protection for various rights of the individuals. Then judicial review is another concrete manifestation of rule of law in constitutional law. So the courts have the authority to interpret the constitution and strike down invalid laws or government actions that violate constitutional provisions. Then separation of powers. We've talked about that. So we'll not belabor that point. But because of time, we'll just come back to and discuss the matter in relation to our own constitution. So if you were asked, for example, to explain rule of law, which is stated in the preamble of the Constitution, how it is reflected in the Constitution, we need to remember that the supremacy clause or supremacy of the Constitution doctrine, which we have in Article 1, Clause 2, that this Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void. Now, this is quite significant because as far as our country is concerned, anything being done or not being done must be in accordance with the law. And we are being told that no law should disagree with the Constitution. If a law is not compatible or is not in agreement with the Constitution, that law is not law as far as Ghana is concerned. So already we have seen how the rule of law is being reflected. And again, if you take chapter 5 of the Constitution, particularly starting from Article 12, for example, we will be told that the fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature. I think let me close the windows that I opened so that I understand I've opened so many windows. Okay, yeah, I think the screen will show now. Yeah, so I was quoting Article 12 just to make the point that the fundamental human rights and freedom enshrined there is supposed to be upheld by all branches of government, by all institutions, by all independent bodies, and by even private actors where applicable. But more importantly, if we are talking about rule of law as reflected in our constitution, we shouldn't forget Article 17. Article 17, clause 1 says that all persons shall be equal before the law. And one of the core elements of rule of law we have encountered or we've learned so far is equality before the law. So our constitution has not defined rule of law in the interpretation session, but the elements of rule of law are littered all over the various parts of the constitution. And that is why I said that someone will say that I may not be able to define the elephant, but when I see the elephant, I can tell that this is the elephant. So what are the things which can let you tell that this is the elephant? What are the things which can let you tell that this is rule of law? So those are the matters that we'll be discussing. And one of them is what? Equality before the law. So if we look at Article 17.1, all persons shall be equal before the law. And Article 17.2 made the point that the rule against discrimination. A person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. So that is to say that no person, no individual is supposed to be treated differently just because of his gender or his race, his color, ethnic origin, religion, creed, or social or economic status. Now, just for interest, just a footnote remark, it is this provision which people have been pushing that some other criteria of discrimination should be included so that the things in respect of which a person can be discriminated against are not only the things stated here, or even if you are using the things stated here, they will be given a very expansive interpretation. So, for example, when we say that you shall not be discriminated against on grounds of gender, gender traditionally is understood in the binary sense, male or female. But then what about those who have become like a transgender? So that is an issue which is emerging. Now, apart, of course, all the other provisions, take the Article 19. Article 19, all the rules on fair trial, they reflect a rule of law. And Article 19, we will be told, especially Article 19, clause 11, that no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in the written law. So that is a manifestation of rule of law. And we talk about the common law offense. The common law offense has been abolished in Ghana, except one thing. So Article 19, clause 12, which says that clause 11 of this article shall not prevent a superior court from punishing a person for contempt of itself, notwithstanding that the act or omission constituting a contempt is not defined in a written law, and the penalty is not so prescribed. So let's keep that in mind. And if you also look at the Article 19 again, the fact that nobody should be put before like a different court based upon the person's circumstances and all the things related to fair adjudication. So Article 19, clause 13, Article 19, clause 19, clause 20. So look at the whole of Article 19 and also look at Article 23, administrative justice. Article 23, administrative justice. And also look at Article 296. Article 296 talks about the fact that if you are given discretionary power, then the discretionary power must be exercised in fairness and you must avoid arbitrariness. So look at Article 296 as well. Judicial independence is also a very important manifestation of rule of law. So if you look at our constitution, it talks about the fact that, yes, we have a judiciary which shall be independent, and then it shall have final judicial power, and it shall be subject only to the constitution and not to any other institution. There are so many cases which have come up which illustrate how rule of law is actually reflected in our current constitution and in our various constitutional attempts. So you look at the case of Asari against the Attorney General. Of course, Asari against the Attorney General, there are so many of his cases, but we are talking about the dual citizenship case, where Professor Asari sought to find out whether prohibition against dual citizen holding certain public offices violated equality rights. So he was trying to say that, okay, if you are a citizen, why is it that some citizens, because they have citizens of other countries, they cannot hold certain public offices? So if you look at the Constitution, and if you look at the Citizenship Act, which Parliament actually passed, certain offices have been stated as being no-go area for those who hold dual citizenship. So he was of the view that that was violative of the equality right or the equality clause under Article 17, among other things. But the Supreme Court took the view that the differentiation was justifiable because the equal treatment applies to those similarly situated. So if you look at Article 17, if you read Article 17, especially Clause 3, let's look at Clause 3 and Clause 4, that for purposes of this article, discriminate means to give different treatment to different persons, attributable only or mainly to their respective discrimination by race, place of origin, political opinion, color, gender, occupation, religion, or creed, whereby persons of one description are subjected to disabilities or restriction to which persons of another descriptions are not made subject to, or are granted privileges, advantages which are not granted to persons of another description. But then there are exceptions which are provided. And if we look at 17.5, for example, that nothing shall be taken to be inconsistent with this article, which is allowed to be done under any provision in this chapter. So if you look at the chapter on citizenship, under which Parliament also made the citizenship law, that aspect of the Constitution is actually endorsing the possibility of certain offices being denied those who hold dual citizenship. So that was a context in which the Supreme Court clarified the application of equality before the law in the Asari case. And in the case of Nate against the Gatti, that case also had to do with the, if you look at the Legal Profession Act, very soon become lawyers. And when you are a lawyer, you provided the legal fee, and you provide legal services, and you've imposed a legal fee on someone. The person does not pay. You need to go to court and actually recover it. There are certain procedures which you have to follow, including the fact that you have to give 30 days notice before you can go to court and all that. So in this case, there was a challenge as to whether that provision of the Legal Profession Act is not being discriminatory to lawyers. And this is what the Supreme Court said. I've just taken part of the opinion of So quote, true object of Section 30 of Legal Profession at 1960 Act 32 was to enable the court to oversee and supervise the charging of professional fees if a dispute arose between a lawyer and his client as to the quantum or propriety of the fees charged, and that compliance with Section 30 of Act 32 was a mandatory precondition for the commencement of an action by a lawyer to recover his fees. This decision provides a rational and legitimate basis for differential treatment between lawyers and their clients. Parliament, with a view to protecting the interests of clients of lawyers, has thought it fit to enact Section 30 of Act 32. So this is a legitimate use of the legislative authority, which is not inconsistent with Article 17, Clause 1, whose meaning has been explained above. In other words, the inequality or discrimination necessitated by Section 30 of the Legal Profession Act 1960 bears a just and reasonable relation to the purpose of that provision, which is to protect the clients of lawyers. The provision does not thus provide for unlawful discrimination or unlawful inequality. It represents justifiable discrimination. It is not arbitrary nor unreasonable. Indeed, Article 109, Clause 1 expressly gives Parliament the authority to regulate professional, trade, and business organization. That article, therefore, confirms the interpretation of Article 17.1, which have been laid out. So in our view, therefore, the response to the issue referred to this court by magistrate is that in the context of the facts of this case, Section 30 of the Legal Profession Act is not inconsistent with the provision of Article 17, Clause 1. So if we look at it, some lawyers will be saying that if I want to sue the client to recover my legal fee, I have to go through certain procedures. But if the client wants to sue me for professional negligence, he can just start the case like any other case without any special procedural restrictions. And that is discriminatory. So that was the point about the case. But the court was saying that if you look at the fact that in the Constitution itself, especially Article 109, if you look at Article 109, Article 109 makes the point that Parliament will pass law to regulate professional organizations. And if you look at Article 19, Clause 5, it says that nothing shall be taken to be inconsistent with this article, which is allowed to be done under any provision of this chapter. So, Article 109 gave power to Parliament to pass the Legal Professions Act, Act 30. And if the Legal Professions Act 30 provide special procedure, which on the face of it appears somehow discriminatory, then the court is saying that it is permissible discrimination, which is consistent with the Constitution. For that matter, Article 17, Clause 1. Now, there are some challenges which rule of law encounter in constitutional arrangements. We quickly canvass some of them. When it comes to emergencies and national security, rule of law suffers or rule of law is threatened. So there may be situations which government may feel that the security of the state or national life is under threat. And for that matter, it may be necessary to suspend certain legal norms in order to protect national security. And this certainly poses a challenge to rule of law. We give you an example. If you look at where we have Preventive Detention Act, just as we had in Ghana in 1958, the PDA, and you know the arrest of senior linguist Shami Bafo Akoto and 7 others, and the Preventive Detention Act, and how the Supreme Court actually reacted. They will not believe at that point. And if you look at that law was supposed to be in the interest of national security. But you see how it could undermine rule of law. How can you make a law which says that a person can be arrested and detained for 5 years without any trial? That is against rule of law. The person has not been tried. The person has not been convicted. And also, the reason for the person detention has not been tested as whether it is reasonable or not reasonable vis-a-vis the alleged threat to national security. So we've discussed that case. Again, when we have military takeovers too, certainly rule of law is seriously affected. And we've had so many. We have military regimes, and they'll make decrees. The decrees will put out to call the ouster clause. Ouster clause to say that no court of law can challenge anything which is done under this decree or not done under this decree, meaning that the authority of the court to intervene, which is a requirement of rule of law, is suspended by this ouster clause. And it usually happens during the military regimes. So if you look at the as per the Salifa, you've seen the two Salifa cases, so we will not belabor that point when we're discussing the constitutionalism and also separation of powers. If you remember how the detention orders which have been made were actually challenged, the legality of same, because the law under which they were detained had not been numbered, had not also been published, contrary to what the National Liberation Council's proclamation has stated. Their proclamation was their establishment, if you like, document. And as you read, and if you haven't read it, I'll be surprised because you've been asked to read it. The court initially ruled in favor of the detainee, but subsequent decisions upheld the government actions. But the point is, if we look at some of these cases, they see how the court struggle to uphold rule of law when you have like military regime. The same thing applies to Kwache versus the Attorney General. When the former IGP have been convicted by the Armed Forces Revolutionary Council Tribunal, he sought to challenge the conviction, and the military tribunal and also lack of due process. Of course, the majority of the Supreme Court upheld the conviction, but Justice Taylor dissented, and in his dissenting opinion, he criticized the lack of due process or legal procedures as is required based upon understanding of rule of law. I mean, notwithstanding the dangers which military regimes pose to rule of law, we have instances too in which the courts have been able to stand their ground to actually say that the government is acting contrary to the dictates of the law. And you know, for example, the case of Shalabi against the Attorney General, the case about deprivation of citizenship when the National Liberation Council was in power, they made a law which was retrospective, a law which was backdated. And the court held that the citizenship once conferred could not be arbitrarily revoked. So here, you notice how the courts, under trying circumstances, could still remain faithful to the call of rule of law. In the same thing, the case of ex-parte Shackelford, that one too, the detention was challenged by habeas corpus application, and the court was prepared to scrutinize legality of the detention orders. And then a case of ex-parte of Osuama, that case too, there was an application for certiorari to quash proceedings and decision of a military tribunal. And the issue arose whether the court had jurisdiction to review decision of military tribunal, despite the fact that there was an ouster clause. An ouster clause is a provision which is put in the law to say that no case can be presented to court regarding anything which is done or omitted to be done under that law. That's ouster clause. So in the ex parte Fusuama, the court held that statutory provision outside jurisdiction must be construed strictly, and the exclusion did not apply to application for certiorari. So we're saying that yes, you can have an ouster clause, but ouster clause cannot affect operation of prerogative rights. Later on, when you are learning contract, in terms of contract, you come across exemption or exclusion clause. And there's a rule which is called the contra proferentem rule. And the contra proferentem rule simply says that when you are interpreting exclusion or exemption clause, it should be interpreted against the interest of the person at whose instant the exclusion or exemption clause was incorporated in the contract. So in a similar vein, where you have an ouster clause, according to Espatu Fosuama, should be interpreted in a very strict terms, should be given a very narrow interpretation. Now, if you look at our constitution, the constitution actually anticipates that there will be emergencies. There could be national disasters and other things. And for that matter, the constitutional order may not be able to function normally, and there may be a need to interfere with the right of the citizenry. So if you look at Article 1, if you look at Article 31, Article 31 of the Constitution to Article 32, you notice that Article 31 talks about the emergency powers. In Article 32, person detained under emergency law. So the president, acting on advice of Council of State, may declare a state of emergency. In 1994, Parliament passed what they call the Emergency Powers Act, Act 472. And that legislation is important because it provides, I would like you to look at Act 472 as well as the imposition of the Restorations Act. It provides the framework which governs how state of emergency may be declared. Because when the state of emergency is declared, what it means is that rights and freedoms cannot be enjoyed normally. And that is why the declaration of state of emergency should be done within strict parameters so as not to abuse the right of the citizenry. So if we look at the law, any declaration of a state of emergency must be approved by Parliament within 72 hours. And the point is to protect fundamental human rights. And if fundamental human rights are going to be suspended, then the suspension or the derogation must be absolutely necessary and proportionate. So the proportionality rule, that is, yes, you can interfere with fundamental human rights, but the interference of it should be proportionate to whatever danger, whatever situation which has arisen, no more, no less. Now, in 2020, not too long ago, thank God for saving us from coronavirus 19. We thought that we're all going to die or from this pandemic. So our lawmakers had to pass a special law called the Imposition of Restoration Act 2020, Act 1012, which was meant to provide a legal framework for imposing restrictions on certain rights and freedoms during emergencies, disasters, or similar circumstances. And you notice how the president could make executive instrument under it and say that all people living in this part of Accra, Kumasi, or Ho, or Tamale, within the next 10 days or the next 5 days, you are not supposed to go outside this perimeter. So if you look at it, the president, acting on advice of relevant authorities, can impose the restrictions on freedom of movement, assembly, and association through executive instrument. And I want you to pay attention to how these legislation, which are meant to respond to emergency situations, are carefully tailored or calibrated so as not to give blank check to the executive to violate the rights and freedoms of the citizen. That is why they are carefully worked out. And if we look at the law, any imposed restriction must be reasonably required in the interest of defense, public safety, public health, or essential service. It must be justifiable in accordance with the spirit of the Constitution, meaning that you can go to court to challenge the restriction which are imposed if you think that they exaggerated, having regard to whatever risk which they are supposed to deal with. But exemptions are also provided under the law. The president may provide exemption to certain persons when he received the experience. So if you remember, health workers, for example, when restrictions are imposed, health workers and other emergency service providers were exempted from the restrictions. And you know, if you go contrary, you pay no penalties, or you could go to prison. So one penalty you need, suppose the 12 cities if it has not been reviewed. Now, if you go to other countries where emergency powers are also dealt with, the US, for example, we have instances where we had emergency in which the rule of law was also threatened. For example, Abraham Lincoln is said to have suspended habeas corpus when there was a civil war in the US in order to detain suspected Confederate sympathizers. So there are a lot of instances in history which shows that in many countries, including in some of the great democracies, when they are confronted with emergencies, they've had to take a desperate measures, which certainly undermine the rule of law. And so if we take Lincoln, for example, when he suspended habeas corpus, there was a case, ex parte Merriman, which sought to challenge, and the court, preserved by the Chief Justice, ruled that only Congress had the power to suspend habeas corpus. But the president at the time, Abraham Lincoln, he ignored the ruling of the court. And his reason for ignoring the ruling of the court was that his suspension of the habeas corpus was necessary to preserve the Union, that is, to preserve the United States as a federation. Then President Franklin Roosevelt, he also detained Japanese Americans by executive order in 1966 during the World War II. So just imagine some citizens who have a certain original citizenship, they were Japanese who are now Americans because of their involvement of the Japanese in the Civil World War, and because they were enemy of the Allied powers, including the United States. They sought to treat them as enemies, so they were all automatically imprisoned by this special executive order. And one of them, Korematsu, brought a case against the US and the US Supreme Court upheld the imprisonment as a valid exercise of executive power during wartime, because the court considered that there will be a grave injustice in failure to protect civil liberties of the rest. Then President Truman, you saw when we were discussing the separation of powers, we cited the case of Johnston, Sheet, and Tube against Sawyer. So you know that case from our discussion of separation of powers. So we will not belabor the point. Now, in the UK too, they've also had their share in dealing with emergency powers and how it affects rule of law. So, for example, during World War II, the UK government had what we call Regulation 18B, Defense Regulation of 1939, and it allowed for detention without trial. You could be arrested and detained, no trial. Now, there was one gentleman called Robert Liversidge. He brought a case, and the case is called the Liversidge Anderson. And the case was essentially whether the Home Secretary's subjective belief was sufficient for detention under the regulation. In other words, if the Home Secretary reasonably believed that someone was a threat to national security, whether that could justify the person's detention, and whether the subjective view of the Home Secretary regarding the threat posed by the person is what matters, or if you use an objective assessment of the supposed risk. So, as I said, Robert Liversidge was detained without trial under that regulation, and he challenged the detention. And he argued that the Home Secretary to be required to show objective evidence of reasonable cause for his belief that he was involved in activities prejudicial to national security. So the legal issue was whether the Home Secretary's belief that Robert Liversidge was involved in activities prejudicial to national security needed to be based on objective facts that could be reviewed by the courts, or if a mere assertion of belief was sufficient. Majority of the court, that is the House of Lords, took the view that the court should not interfere with executive discretion in matters of national security during wartime. And for that matter, they ruled that reasonable cause was a subjective standard pertaining to the Home Secretary's personal judgment, not subject to judicial review. Of course, we can say that the House of Lords were afraid of the danger in which society found itself during the Second World War. So they didn't want to stand in the way of the executive to try and protect society. But one of them, Lord Atkin, just like Lord Taylor did in the Kwachis case, Lord Atkin dissented. And Lord Atkin's dissent was that the term reasonable cause implies an objective standard that should be open to judicial scrutiny. And he made a statement called, he cautioned judges against being more executive-minded than the executive. In other words, weeping more than the bereaved, as it were, and emphasized that amid the clash of arms, the laws are not silent. So that is an interesting quote. Amid the clash of arms, arms as in like the guns and the bombs, the laws are not what? Silent. And he stressed that the legal principles which protect individual rights should be upheld even in times of crisis. Now, if we wanted to draw the historical line of where we have been as a country, Ghana, as far as the rule of law is concerned, we look at the pre-independence situation, and we notice that our colonial legal system, we inherit the English common law and the various statutes by reason of the Bond of 1844 and also Supreme Court Ordinance of 1876. Your legal system, you have come across more of this, so we will not belabor the point. You notice what we call the rule in Angu versus Atta, where indigenous customary law was only recognized where you could bring evidence to establish that those customary laws existed. Now, after independence, we tried so many constitutions, the independent constitution, and of course, the first Republican Constitution, the second Republican Constitution of 1969, the third Republican Constitution of 1979, and then the fourth Republic Constitution of 1972. And if you look at all these constitutional experiments, of course, with the exception of 1960, it's not the case that 1960 did not reflect rule of law. There was opportunity for rule of law to have been articulated, but just because of one major decision, which the Supreme Court was not bold enough to have actually stated what the law was, obviously because of the fear of the overbearing President Nkrumah at the time. Otherwise, if you look at all the various constitutions, the 1957 Constitution, 1969, 79, and present Constitution, we have made modest efforts to actually entrench, incorporate rule of law in our governance. And no wonder, if you look at the World Justice Project, the rule of law index, at least this year we are ranking 62. It's not the best, but it's also reassuring that we are not doing bad as far as rule of law is concerned. And this has been going on for many years, despite the fact that we have had even the military intervening in our politics. Okay, so just a quick recap of constitutional provision of rule of law. You talk about supremacy of the Constitution, that we have the fundamental human rights, separation of powers, judicial independence, and the fact that we have a judiciary which actually interprets the Constitution, adjudicate disputes, and ensure that government actions comply with legal requirements. Courts have also played their role in upholding constitutional provisions and protecting rights. Then the other point we are making by way of recap is that the legislature has also got a role when it comes to rule of law. In terms of process, laws are enacted by democratically elected parliament, which follow procedures outlined in the Constitution. And this actually reflects all the points which we'll be discussing as constituting the elements of rule of law. And when it comes to law enforcement, of course, we have the challenges, issues of corruption, resources limitation, and training, which impact effectiveness and fairness of law enforcement. So that one is there, but rule of law, just like various theories that we are learning, is not an event, it's a process. So as to how well you are faring, we are not, it's a process. So we can draw a graph and then we can say that regarding these particular aspects. We've done so well, and that is why maybe I'd like you, if you get time, to look at the World Justice Project, the Rule of Law Index. I find it quite interesting. And of course, as I keep telling students, constitutional law keeps evolving because of new ideas. Many years when we were students learning constitutional law, some of these ideas like World Justice Project, Rule of Law Index, did not exist because we did this in 1987. But here's the case, some people have gone forward with some of these ideas and have developed tools which enable us to even assess how well rule of law is reflected, rather than just letting it remain as an abstract idea. Yes, I think I saw somebody's question. Yes, yeah, so somebody has answered us that the separation of powers was actually included. Yeah, so, but military regimes in general, as we have seen, is a big problem. It's not a normal thing to have, as Justice and Professor Modibokran would say, the man on the horseback. That is a very cynical way of referring to the military who intervene in the governance of states. It's not normal for the military to take over the arms, the governance of a state, but when it does happen, it actually undermines the rule of law in a very severe way, because they will make their proclamation and say that the constitution has been suspended. If the constitution has been suspended, then rule of law has been given a big blow, isn't it? Now, you notice that rule of law in our current constitutional dispensation, most of the references are to the constitution. So just imagine, if you say that the constitution is suspended, then where do you go from here? We talk about corruption. Corruption is another challenge to rule of law project generally, because it erodes public trust and also undermines legal institution and impedes justice. Rule of law requires that all of us are subject to the law, that we have impartial, accessible courts, we have law enforcement agencies, everybody doing this rule under the law. So where people who are supposed to, for example, enforce the law are corrupt, then how will the public have confidence in the institution? But there are efforts to address corruption. There is what they call the African peer review mechanism under the auspices of the African Union. Now, when it was established, I think in 2006, Ghana and Rwanda were the first countries to subject themselves to what they call the self-assessment. You invite the peer review mechanism panel to visit your country and then evaluate you regarding your governance structures and systems, and observe the deficiencies and also where you are doing well. So where there are work to be done, your attention is drawn that maybe with respect to corruption, with respect to access to justice, with respect to this, you're not doing too well, you could improve. And then based upon the report of the African peer review mechanism, you take the necessary remedial measures. So you can just go to the African Union website and you notice that there's a small portion on African peer review mechanism, and it will reinforce this point that I am making. So subsequent to the African peer review mechanism and other review on Ghana, some efforts have been made to try and address corruption. Of course, the Commission on Human Rights and Social Justice already in the Constitution is given the power to investigate complaints of corruption. But as you will notice, the case of anane no ex parte at the anane where the court will say that where Shraj just not received a complaint, it cannot just see a complaint in the newspaper or somebody talking about something and just take it up. That there must be identifiable complaint before it can investigate like the corruption against like a public office holder, as it were. Of course, that was a low moment as far as the effort to fight corruption is concerned. But now we have the YOCO, Economic and Organized Crime Office, and we also have the Special Prosecution. So many things are being done to try and address corruption. Also, access to justice. We have the Legal Aid Services, and the Legal Aid Commission, which is there to help those who are financially impecunious to be able to access justice. And also ADR, Alternative Dispute Resolution Mechanism, is also there. Various mediation centers have been opened so as to enable people to have places they can get their dispute settled. Yeah, with human rights issues, we are not doing bad, although we are not there yet. But if you look at the various reports, some progress has been made. Now, just before we leave tonight, general criticism of the concept of rule of law. Commentators or scholars have observed that one limitation of the concept of rule of law is its abstract nature. And by this, they mean that rule of law is often conceptualized in broad terms, and it makes it difficult to define precisely. And I'll be telling you that just like the elephant, I cannot define it, but I can show you one. So that is how rule of law by and large has become. And vague definitions can lead to varying interpretation and application. So that is the danger. If you cannot define it precisely, then it becomes quite fluid, open to various interpretation to suit agenda of the person trying to interpret it. There's also implementation gap. So there's often a discrepancy between the ideal of the rule of law and its practice. So we talk about corruption, lack of resources, political interference in the legal system. They all affect the rule of law. And I'll give you an example. You remember Apollo, is it 568, during Prime Minister Buzia, following the Salas case. And the court said that the government could not just sack people like that. How the Prime Minister, leader of the government, was upset, and how the Dawn broadcast to try and castigate the court. And not only that, you've had other instances. Even recently, we have had the Supreme Court giving a decision against the Speaker of Parliament, and how various people in society have gone to the media to actually castigate the Supreme Court for doing its constitutional duty. There's a school of thought we called legal realism. Later on, when you are learning legal methods, you discuss a little bit of a legal philosophy or nature of law. Legal realism, especially the American legal realism, they hold the view that when we talk about law, law is not just what is contained in the law, especially when it comes to law being applied through judicial decision making, that the judges who apply the law, they have so many biases from their background, their value system, their thinking and preferences. And all those things feed into how they understand the law, how they apply the law. So to know the law, we must also be conscious of some of these biases. So they say that law is influenced by social, economic, and political factors. And if that is the case, then it becomes difficult when we are talking so much about rule of law, because the law is not value free. The law is not neutral. The law is colored. Then the critical legal studies, they also reason like the Marxists, that law is a tool used by dominant groups to maintain power structures. And for that matter, they think that rule of law, if it's taken too serious, may perpetuate inequality by reinforcing existing hierarchies, especially when it comes to this gender discrimination, affirmative action issues. Yeah, so in a nutshell, these are some of the criticisms which are out there. Now, just before we go, there is one aspect, because of time, but I don't want to come back to this topic again. That is why I am rushing through. But there's one aspect I want you to pay attention to. That is the International Commission of Human Rights, or International Commission of Jurists and the Rule of Law. They had a Congress, as I told you, in 1959, and the document they produce is very important in trying to shape our understanding of the rule of law. Now, the International Commission of the Jurists, they regard rule of law as a living concept permeating several branches of the law and having great practical importance in the life of every human being. Constitutional law, administrative law, criminal law, organization and function of the judiciary and of the bar. So they produce a document called the Declaration of Delhi. And this Declaration of Delhi, in it, they talk about universal application of rule of law. That is to say that rule of law is not exclusive to Western democracies, but is universally applicable. It applies to every society. So all nations, regardless of their political, economic, or social systems, should uphold legal principles. Then they also talk about protection of human rights. They talk about guidance for emergence nation, that is country which were coming from colonial rule, had just gained independence, how they too embrace a rule of law. And in that regard, they stress the importance of developing legal institutions in those countries to prevent arbitrary governance and protect citizens' rights. Then they also talk about influence of rule of law on international law. So these are the things that I would like you to pay attention to. You read the details in the news, which I will put on the platform.